Hey everyone, it's Beverly Hallberg. Welcome to a special pop-up episode of She Thinks, your favorite podcast from the Independent Women's Forum, where we talk with women and sometimes men about the policy issues that impact you and the people you care about most. Enjoy.
Hi everyone, this is Jennifer Braceras, Senior Fellow with Independent Women's Forum and Director of IWF's new Center for Law and Liberty. Today we're talking about property rights, and more specifically about a recent Supreme Court case that represents a major victory for American property owners. The case is Knick versus Township of Scott, and it was brought by a woman named Rose Knick. One of Ms. Knick's attorney, Christina Martin, of the Pacific Legal Foundation, is here with us today to talk about the important Supreme Court victory. Welcome to the She Thinks podcast, Christina. Thank you so much for being here.
Thanks for having me.
And congratulations on your important win.
Yeah, we were very excited.
Can you tell us a little bit about, for people who don't know the background, tell us who Rose Knick is and why she brought this case.
Well, Rose owns a farm in rural Pennsylvania, and the local township there passed a really strange ordinance that essentially opened up her private property to allow strangers onto her property 7 days a week. The reason was that the town had sent some local officials to snoop around on her property. They found a few loose, unmarked stones, but they thought they might be gravestones, so they just unilaterally decided there was at least one grave site. And under a local ordinance that had just been passed, they declared the area cemetery and threatened Rose with $600 per day fines if she didn't treat it like a cemetery and open it up to the public and maintain the area as if it's a cemetery.
Wow. So did they think that it had some historic significance, or what made them initially think that there was something there that the public would want to see?
Well, there's a gentleman in town that apparently thinks there's an ancestor from some long time ago who might be buried on her land. And so he's been saying this for some time. Whether he asked them to go or not, I don't know. But the bottom line is it's pretty well known in the community that he thinks someone is buried there, I suppose, because we read it in the paper. And the local officials went to her property, snooped around, and they declared it a cemetery. She doesn't believe there's a cemetery on her land. But
and
even
I'm
if
sorry,
there were,
you may have said this before, but how big a piece of property is this?
90 acres, and it's a working farm. So there's obvious concerns about liability of people walking around on a functioning farm. And she lives on this farm, and she's an elderly lady. She doesn't want strangers wandering around whenever they want to. So obviously she had concerns, and fortunately the Constitution requires that when government takes your property without paying you for it, as they did here, they imposed something called an easement. That means people can go on your land. In this case, it would mean that people could go on her land without her permission. And normally you would have to pay for an easement, but the government did not do that, and that violates the Constitution. So she filed a claim originally in state court, but the local government dropped the claims, and then the local court wanted her to wait around until they filed a civil enforcement action against her. So she went to federal court to enforce her rights because she wanted to know, am I going to be fined $600 per day? What are my rights? Am I going to lose my property? So she went to federal court, but the federal court threw her out because of a 34-year-old decision that we just recently got overturned. And that is a case called Williams and County Regional Planning Commission versus Hamilton Bank of Johnson City. And in that case, the U.S. Supreme Court closed the federal courthouse doors to these claims, and it was based on a wrong presumption. So the court said in that decision 34 years ago that really you could bring a takings claim in federal court, but before you could do so, you would have to go to state court and file your claim there. And if you lost, then you could go to federal court. The problem is that the law doesn't allow you to have a second bite at the apple. And they decided that years later. The Supreme Court said, well, our presumption was wrong. Once you lose in state court, you can't come to federal court. So in effect, they closed the federal courthouse doors to these claims, and they turned the takings clause, that property rights protection that government has to pay you when it takes your stuff, into a lesser protection than our other federal constitutional rights that allow you to go straight to federal court to enforce.
So just for our audience members who are not lawyers, if we could just break this down to the simplest terms, what was the thinking of the court in the earlier case where they said you have to go to state court first? What was sort of the rationale for why they thought at the time that made sense?
Well, honestly, it was not even properly briefed. The question was really another question before the court, and they decided that a property rights claim, in that case, a takings claim, was not yet ripe because they needed to apply for another permit before the court would know how these local regulations acted on the property. And so they said that it's not ripe yet. But then they went on to say, and anyway, you'd have to file in state court and lose before you could come to federal court. And the reason that came up, interestingly enough, was because the attorney for the United States who filed something called an amicus brief, it's a friend of the court brief, so that wasn't a party, but they were filing a friend of the court brief. They came up with this theory, and neither of the parties were arguing this, but the U.S. government argued it, and it ended up in the Supreme Court's decision. And this time around, when we took Rose Knick to the U.S. Supreme Court, the federal government did a 180, and this time they admitted that actually, you should be able to go to federal court because that's what Congress intended. And so we were really pleased that the Solicitor General for the United States supported Rose. But yeah,
so
you asked what their reasoning was. There wasn't a lot.
There wasn't a lot. And what she was seeking essentially was not to reverse the decision of the government to let people on her property. She was simply asking to be compensated for that, for the public right of way, so to speak.
Well, I think originally she did want to stop that, but really she'd be happy either way. She just doesn't want to be subjected to fines for, protecting her property rights. And that's really what the heart of the concern is for Rose. And what's going to happen now, because of this U.S. Supreme Court decision, she has now just finally won the right to bring her claim in federal court. So this is all So for property owners across the country, for anyone who has that situation where government takes their stuff, and this is something that's only been an issue when local government takes your property. You would be thrown out of federal court and you'd have to go to state court. But now you're going to be able to go to federal court.
Right.
But
so the Supreme Court case that you won wasn't a determination in your client's favor on the merits. It just gave her the right now to pursue her claim in federal court and figure out what her rights are and exactly. Get compensation if the government has, in fact, taken her property.
Yeah, and so people everywhere are going to benefit from her decision, but her fight's actually not over.
And will you continue to represent her in the lower courts?
Yeah, well, that's the plan. Yes, the plan. And hopefully, we're hoping to, get her justice.
Right. So now I understand that this was a 5-4 decision, and to me, from everything I've read about the case, it seems like a pretty open and shut case. It almost seems like there was a glitch in the law that, the Supreme Court made this ruling years ago, almost, offhand on a matter that you said wasn't originally briefed and probably didn't understand how it was going to all play out. And it seems like it's a pretty common sense decision that, yes, people should be able to go to court and enforce their constitutional rights just like they could if their First Amendment right were violated or any other right. But there were 4 justices who issued a strong dissent led by Justice Kagan. And what was their reasoning for opposing the decision?
Well, they had 2 reasons, and one was they were concerned about the precedent that was being overturned, and they pointed out that not only does this overturn Williamson County, that 34-year-old decision, but it also arguably overturns much older decisions that held that as long as government gave an easy way to collect your money, so in other words, they set up you didn't have to go to court to get paid in these cases, but the dissent kind of elided that point. You would just literally go collect your money for the property that had been taken. But they said that this is inconsistent with those decisions too. And so really the court's overturning a lot of precedent, and that troubled the dissent. But also they were worried that government officials would accidentally violate people's property rights, that they would pass all these regulations, as they often do, and accidentally violate property rights. Before, they would say, well, there's no violation until the property owner goes to court and sues. And then there's still no violation because the government pays when the court says you have to. But it's sort of a fiction, because in all of these decisions for years, the court would say, yes, this violates your property rights. They took your stuff without paying you for it. The Constitution requires they pay you. And so, it's just a disagreement in a sense about what's been going on. But the dissent was really just concerned they don't want officials to be accidentally violating the Constitution. But there's plenty of easy solutions for that, like maybe be a little bit more careful about when you regulate away people's property rights, or when you impose easements on people's lands. The burden for the individual when this happens is extreme, but for the government, it's really not a big deal.
And also, I find it curious because it's not as if these government bureaucrats are being sued in their individual capacities, right? I mean, nobody's going after some town clerk and trying to take them for all they're worth because they issued a regulation that, had a financial impact on someone's property. What they're really doing is trying to get the town or the state or whatever the government institution may be to make them whole for their taking, right? So they're not, the court's concern with, these poor government bureaucrats and regulators might get hauled into court seems to me to be a little disingenuous, because they're not really at risk of, being sued personally.
Absolutely. Yeah, no, they're not really at risk unless there's like a specific court decision on that exact specific thing that they're doing in that case, and that just doesn't really happen in land disputes.
Right. Interesting. And then, of course, their argument about precedent seems to me a little, well, I know this is a big, dispute on the court jurisprudentially overall, but it seems to me if a decision was wrong, a decision was wrong, right? And, Dred Scott was wrong. We wouldn't let that stand today if it were to go before the Supreme Court. So, I'm more interested in sort of what their view on the merits is, but as you say, it seems to be that they just were concerned with these government bureaucrats, which doesn't make a whole lot of sense to me.
I agree. I mean, that was one of the arguments that was raised by the town during oral argument, and to me, it just doesn't seem very compelling because, again, you have the government here that is ultimately, it's not a big deal for them if they lose. They just have to pay the person. Okay,
right.
The entire regulation's ordinarily not going to be overturned. But, for a person whose land is being taken away without first paying for it, it's debilitating. And many people, the stress and fear that goes along with that, they're losing their property, they're having, there's a lot more cases that are more extreme than Rosenicks, where it's really a scary situation for the owner, and financially crippling. And so for the government, it's not a big deal. For the bureaucrat, they're not going to lose their property if they lose, ordinarily anyway. Maybe you can come up with some extreme situation where they're intentionally persecuting an individual, but that's really a different case altogether, and that's not what the court was concerned about. Right.
And so, you said before that, the reason the average person should care about this is that it means anyone who owns property, if the government does come in and take their property in any way, shape, or form, they now have a right to seek redress in federal court. Could it be that the dissent was concerned that this would open up the floodgates and, quote unquote, make the proverbial federal case out of property disputes?
Yeah, they did. They did express concern about that. That Justice Kagan wrote she was concerned federal courts would be deciding state law matters. But federal courts actually will certify a question for a state court to answer all the time. This is not uncommon.
Right.
And they're also capable of answering a lot of these questions because there is state law on it. And just as state courts often weigh in on federal matters.
Right. That makes a lot of sense. So tell me a little bit about your organization generally, because I know you work for the Pacific Legal Foundation, which represented Rose Knick, and you do a lot of work in this area and property rights. And I'm wondering if you could tell our audience just a little bit about your mission and maybe some other interesting cases you might be working on right now.
Yeah, absolutely. So Pacific Legal Foundation is a nonprofit public interest organization, and what that means is we sue the government to set precedents that help people everywhere. And we have a few areas that we're really passionate about and that we have a long history with protecting rights. One of those is people's right to their property, that if government takes their property or regulates away the use of their property or uses the permitting process as an opportunity for extortion, that it violates people's rights, and people should have a right to be paid when their stuff is taken and to not be subjected to extortionate demands and whatnot. We also do a number of other types of cases like free speech, and we've got some separation of powers cases. But my very favorite type of case right now is a case that I'm lead on and that I'm really excited about because I think we could get some a big difference soon in Michigan and about a dozen other states. And that's in Michigan. I have a case pending before the Michigan Supreme Court where our client accidentally underpaid his property taxes by $8, and the local government took the property to collect the $8, sold it, and kept all the money.
Was this a home or just a piece of land, or what type of property was it?
It was a rental home. So our client, Yuri Raffelli, had invested in 2 homes. This was his more valuable one. And, he's an elderly gentleman, was looking for a source of income, as many people do. Anyway, so the government took it, and he had no idea he owed the $8. Yeah, it's shocking. Nobody thinks it can happen in America, and it shouldn't happen in America. In fact, people at the founding of this country had better property rights, and you can go all the way back to England and to Magna Carta, and people had better rights when they owed the king money than what Michigan is currently giving.
So what happened? I mean, it says if the guy shows up at the town hall and says, gee, I didn't realize I owed you $8, here it is, don't they at that point say, okay, thanks for the $8 and move on? I mean, what makes them seize the property?
Well, because it's extremely profitable, and so the law gives them authority to do this, and of course, Raffelli didn't know he owed the money. Raffelli's elderly. His son-in-law drove over to meet with the treasurer and actually waited around in the office all day, spoke to him, and his son-in-law tells me that what happened was he pleaded with him, please let us get this property back, and he was essentially told to go pound sand, like you snooze, you lose, which is, I think, shocking. And what we've learned is this is actually happening to a lot of other people. And I was just in Detroit yesterday and the day before because we filed a lawsuit for another client who lost their property where they were going to live for $144 debt, property tax debt that they didn't know about. They paid the subsequent taxes. The Wayne County sold it for $108,000 and kept all the profits. And this is legal in Michigan, but it's unconstitutional. And the Michigan Supreme Court's agreed to hear that $8 case. We're hoping to set a precedent that ends this practice. But there's, like I said, there's about a dozen other states that are doing something similar, a variation, although Michigan might be the worst. And we'd want to end the practice in those states too.
Yeah. Well, thank God for the United States Constitution, and thank God for lawyers like you who are out there helping people vindicate these rights. That's amazing. It really is.
Yeah, it's a lot. It's a lot of fun because I think a lot of people don't appreciate how many rights people have had in history. And I think we often look back on the past and assume that things were always very bad because that's kind of the popular thing to do right now. But there were a lot of rights that have been lost and that we should bring those back. Like, it's good that we have more rights in some areas now, right? But we should bring back rights that have been lost in some places. We should, because these are obvious, common sense rights. When the government is being allowed to do something that private people could never get away with.
Right.
And there's
the
for good
interesting
reason.
thing is, we have a written constitution, right, that protects our rights against the government. But if people don't sue to enforce those rights, the government can actually get away with quite a lot, right?
That
I mean, the Constitution is a piece of paper, and unless we have advocates, to help us bring our claims, then it's a meaningless piece of paper. So I think you're really doing fabulous work.
Well, our clients deserve a lot of credit too, because it takes a lot of resilience to stand up for your rights. In some cases, people don't have a choice, but in many other cases, they do, and they fight anyway, even though it's hard.
Right.
And often they spend quite a lot of money before we even find out about their case and step in and are able to provide them with free legal representation. But in any event, you're absolutely right. If you don't stand up for your rights, then they can be lost.
Right. Now, so where can people learn more about your work in the Pacific Legal Foundation? How can they read more?
So pacificlegal.org, and we also have a Facebook page and a Twitter page, but you can read our blog at pacificlegal.org or read more about our mission statement and what it is that we do there. And we have a number of videos on our social media pages that people can watch about our cases and other work.
That's awesome. Well, and as we begin to launch our Center for Law and Liberty, I hope that we have an opportunity to collaborate with you in the future. I think it'll be a nice synergy there.
Love that idea.
Yeah. Well, we'll keep in touch on that. But so that about does it for today. I hope that everybody learned something new from today's conversation and talking with Christina about her interest in property rights. If you enjoyed this episode of She Thinks, we would love it if you would leave us a rating or a review on iTunes or share this episode on social media. From all of us here at Independent Women's Forum, you're in control. I think, you think, she thinks.